outside the house for help in Dallas, Texas. You can look his name up. He's actually like.
Well, did you file on him for kidnapping?
Yes, sir.
What happened in the case?
Bruises. He's personally in jail right now because of this.
All right.
I have bruises there.
Once again, but for 4 months, you haven't had a device? We can't hear what you're saying.
I never shot. I never had a gun. I asked them right there to test me for gunpowder residue. They didn't, and they had cameras and everything, and the police even said they didn't see.
All right. We got a problem, so.
You know, I've spoken to my client a little more about this ankle monitor issue, and I think we have to like kind of what happened.
We got a problem. I mean, they state that it was deactivated 4 months ago. And where is your monitor?
It's on my leg, sir.
But it's dead, right?
Yes, sir. It is.
It's charged, Your Honor. I think she's charged. It's charged, right? Or is it-
I've been trying.
No, he deactivated, so it doesn't matter. It's,
Back in
she can get charged, she can use it as jewelry, but it just doesn't do any purpose. It doesn't serve
I
any
think, Your Honor,
purpose.
as she
Otherwise.
has, I'll let you know kind of what happened in that time period.
Yeah.
Doing.
Can she speak, Your Honor? Can you explain what happened?
Yeah,
I've already talked to
this is your time because I'm about to make some orders that are going to affect your freedom. Go ahead.
4 months ago, I was pregnant. I ended up being in a relationship with somebody. I didn't know them that well. I do childhood, and whenever time I did that, I was getting away from something. I went there. It wasn't the best situation. I ended up getting pregnant during that time. That person beat me. He tried to sell me, like sex traffic me. I was fighting. He beat me with.
How is it somebody else's fault that you didn't pay for your ankle monitor? How is that somebody else's fault, man?
I was being held captive at the time, and I
For
basically
4 months you've been held captive?
I didn't.
This has been deactivated for 4 months. Nobody does that.
I literally had to scream outside the house for help in Dallas, Texas. You can look his name up. He's actually like.
Well, did you file on him for kidnapping?
Yes, sir.
What happened in the case?
Bruises. He's personally in jail right now because of this.
All right.
I have bruises there.
Once again, but for 4 months you haven't had a device that you were supposed to have, and that's your problem. You're charged with deadly conduct here, and there was a good reason that we made sure that we wanted to know where you were, and this happened where?
The incident or with this?
Yes, the incident. No, that you said that this person.
Dallas.
I went to Houston with him.
What are you doing in Dallas?
He took me all the way to Dallas, and he took all my.
What are you doing in Houston?
That's what I was trying to explain.
See, that's why we have these devices, so we know where you are at all times.
Yes, sir. And during that time, like basically, he took all access to everything. I basically had to stand outside the house and
You made a choice of who to pal up with.
You're right. And
That's your
I
problem.
left that situation. And so I was getting back. And I just never had a chance to pay. Like, I can pay today. And not only that, like I don't have no issue. Like my only thing is
You got a big issue.
I didn't do it.
You got a big issue on this order of the court.
I'm just trying to get past this. I can't go. Like I don't even know what to do. Like I don't know.
That's where you're headed. I mean, that's where you go when you don't follow the orders of the court. For 4 months, my goodness. I didn't know about this.
And the only reason why you put it on me just to make sure I wasn't late for court. Like I didn't show up for court and I showed up for court. That was the only reason why you put it on me. I never been in trouble before. I ain't run.
It doesn't matter. The court can for good cause, any good cause, order bond conditions.
Yes, sir.
But what you've told me is you decide when the bond conditions and what bond conditions are going to be followed. Not me, and I'm supposed to be the one setting it. But for 4 months, you have been violating a condition of bond, and then we kind of stumble upon it because we have so many cases. We can't be watching everybody. We have to trust that they're going to follow the rules. And
And-
Sometimes it happens where you, a day or two and there's no harm done, but we're talking about 4 months.
And I still thought.
And then you're getting involved in issues, criminal issues in other
No, I
counties.
didn't get involved in criminal issues.
You were
That's the
part
thing.
of something
No.
that was, you
I
said,
didn't do anything.
you want to just continue to just interrupt me through this whole thing? It sounds like you're the kind of person though that kind of bullies your way into your way. You want it on your terms, and when you don't have it on your terms, then you interrupt and you make excuses. But the bar is set for everybody, and they have to get over the bar. And you hadn't been over the bar in 4 months, and that was something that you had an obligation to tell me as much as the bondsman did. But you haven't been following a condition of bond for 4 months. My goodness, that's serious, very serious. And what we normally do in the cases like this is your bond is revoked. You're in jail, and we'll sit this out until we can dispose of this case. That's what happens in all the cases. Sorry, but you had a chance. I have to be able to trust you, and I don't. This is a big gap of a problem.
I think, Your Honor, the argument she's trying to make.
We're talking about a crime of violence that you've been charged with.
It's no.
Well, you're presumed innocent, but the grand jury says there's probable cause to believe you did. Because of that, I have to rely on that as a probable situation. So that's why bond conditions are set. And that's all we're talking about.
Your Honor, I think the issue was because she got involved with someone who ended up being in a very violent, bad situation, who got taken kind
I'm talking about 4 months not telling me about.
Well-
That's what we're talking about.
Well, we don't. She just recently got free, and that so she was kind of held for him for a while. So that's,
No, when I can see that for 4 months she's been held kidnapping, she's been kidnapped for 4 months, let me know. But I haven't read about that in the paper, and that would make the news. Don't tell me that you hadn't in 4 months been had time. And John, here's what we'll do: is I'll give you a hearing on it, and y'all can produce witnesses. But until then, she's it defies logic that she has been held captive for 4 months, and I want to see some proof of that.
we'll get that, Your Honor.
All right, all right.
Okay. We can be in custody for now. So
Your bond is revoked. Yes, because you hadn't had a monitoring on it. You hadn't called me about it and talked to us.
Possible.
And it was deactivated a long time ago. That's your responsibility. It's a condition of bond, and you must have that, or you're not released, You must have that, but I've already,
Completed.
you're going to interrupt me all day long. Is that what it is? Boy, that's rude.
No, sir.
I mean, if there was a crime for that, you'd be guilty of that one because you interrupt. Anyway, that's what I'm going to do, John, is those findings and see what y'all, I don't know what y'all plan to do in the disposition, but you can have some time, talk to her before we send her.
Absolutely. That's what I'd like to do.
But I've got to have some conditions that, so we know that she's supervised, and you're not being supervised by the court, and that's what you're supposed to be. And you are on your own supervision, which is not the way it works. All right. Well, let me know. Thanks, John. We're here for business. Okay. Who else? With her attorney, waive a formal reading of the indictment and the arraignment here. Can we proceed as such?
Yes, Your Honor.
In summary, this indictment alleges that on or about April 15th, 2022 in Jefferson County, Texas, you committed the third-degree felony of deadly conduct. Do you understand what you're charged with here?
Yes, sir.
Yes. If convicted, you face no less than 2 nor more than 10 years
Yes, sir.
confinement in prison, and a fine up to $10,000 can be assessed for any third-degree felony. Do you understand?
Yes.
An agreement has been reached in this case. Can you read that into the record?
Yes, Your Honor, the agreement is a cap of 6 years.
6
Yes,
years?
sir.
All right, so we're looking at no less than 2, no more than 6 years in
Right.
prison.
Or probation, deferred probation. I think she's open to all of them.
Deferred or unadjudicated probation up to 10 years. What about regular
I
probation?
think she's eligible for regular probation too. She doesn't have
I can't remember. This is kind of a weird one, isn't it?
It's deadly conduct with
On
the
deadly,
firearm, isn't it?
yeah, I know, but didn't we
If it
have
has a deadly weapon attached to it, can it be?
It's 3G. I don't
remember?
Registration was available. That is perfect, sure.
Under subsection B, it says it does not apply to a defendant when it's shown that a deadly weapon was used or exhibited during the commission of a felony offense or immediate flight therefrom. And then number 2 says, and the defendant used or exhibited the deadly weapon.
Mhm.
And so this is not a law of parties. This is, we're accusing her of doing this.
Sorry, what?
Yes.
No, it's just weird that it wasn't. I guess it didn't mean it wasn't specifically
Stated in there.
enumerated
Right.
in the numerical sequence of crimes. Didn't we have?
Because
That's how we dealt with this issue one time, and we had a bunch of disagreement over it, but it clearly says any offense involving where the use of a deadly weapon. I mean, it wouldn't make sense. It wouldn't apply. I mean, I don't, the elements of deadly conduct certainly seem to be
All right, in there.
no less serious than
Because in the indictment,
a deadly weapon
knowingly discharge a firearm.
was used or exhibited.
I guess there are ways on deadly conduct that you could recklessly engage in conduct that places another in imminent danger or serious bodily injury without using a deadly weapon.
Right.
So it's only if there's allegation of a firearm and that they use and exhibited one, a deadly weapon.
I think there's other ways to get deadly conduct without getting a deadly weapon. Which doesn't make sense.
All right, so it looks like those are the only 2 options. Deferred or unadjudicated.
2-6.
An agreement has been reached. Again, where whatever sentence shall not exceed a cap of 6 years in prison. And is that your understanding of the agreement? If I follow this, you have no right of appeal of your case. Do you understand? How do you plead to this indictment charging you with the 3rd-degree felony of deadly conduct? Guilty or not guilty?
Not guilty. I mean, guilty.
You got to pick one.
Not guilty. I mean, sorry, guilty.
What's your, think about it, relax. Okay, what is it you're going to plead?
Yes, Your Honor, I think. We'll
Okay, I want everybody to
Hey, that's
sound in on this.
Yeah.
What?
okay. Yes, Your Honor, I think she wants to move forward today and not do a PSI.
Okay, go ahead.
Your Honor, I would request in this case my client give deferred probation. Some of the reasons why is that she has no criminal record. She had this. I think she has some pending misdemeanor charges that may be related to this or sometimes after that, but it's not. She has no convictions for that. So the fact that she has a clean record, this was a disagreement regarding her her child's father, however you want to describe him. She apparently had a dispute with him. A gun became involved. She had a gun for her protection. And then somewhere along the way, there was a shot fired. Luckily no one was hit with the shot. she, has been cooperative in court, even though, like I said, this morning we had an issue regarding the ankle monitor. She was here to be on court, on time here, didn't have any issues there. And I think I'm looking at here.
Notice how the judge's focus shifts here. The defense is asking for probation, but the court is looking at the alleged use of a firearm and the potential danger to others. In sentencing, public safety often becomes the deciding factor.
Looking at here, the other misdemeanor is pending is evading arrest or detention. I think when the cops got there, she did take off running from them, or I'm not sure the fact that I know she was charged with evading arrest and detention as part of this offense. Your Honor, this is the case where we were here this morning and her bond was revoked. She, at that point, said she wouldn't have taken the deal. We were kind of working on a deal with the state.
It was revoked because of this
Ankle monitor, yes,
She wanted
absolutely,
that.
yes.
ankle monitor.
But prior to that, me and Mr. Laird started negotiating a deal on this, and we were going to reset it for just a little more time to negotiate a little further to try to get her. I was going to request from the state probation, and I think that's why Mr. Laird did offer the cap, whereas they were not going.
This county's just turning into just one place after another where everybody's using a gun, and nobody ever settles their fights with words or anything else. I'm trying to remember. I mean, there was a lot of things going on out there. It looked like there were a bunch of people, but witnesses all backed up the complainant in this case that she also had her children in the truck and pointed it at a group of people. And I think she actually fired one shot at the group. When they got to her, she had 3 outstanding city warrants, of course.
How'd she miss the group? We can't hear what you're saying.
I never shot. I never had a gun. I asked them right there to test me for gunpowder residue. They didn't, and they had cameras and everything. And the police even said they didn't see nothing. The only people who said that I shot was his recent girlfriend and his childhood best friend. I was in the car. Everybody else can testify and said that I stayed right by our apartment. The incident happened right by the park. I never had a gun. I promise. Mother Great, I'm gonna pass away.
Well, then how did we get to
Fired.
how did we get to this charge if you didn't have a gun? Well, but you just pled guilty under oath saying you had a gun, that you threatened these people with firearms.
You're in a catch-22. I mean, this is what the crime is that you just pleaded guilty to. And you knowingly discharged a firearm in the direction of a person. And that's one of the elements of this crime. That's a problem. You either admit it or you don't. And if you don't, that is all.
I am number 2 this coming Monday next door.
Okay.
That'll be at 1 o'clock. So Monday morning.
Okay.
I'll say guilty. I just don't want to go to jail. Can I do that right now?
No, you can't do it now. You've already said enough. You kind of put yourself in a bad position. You can't, all right. What's next?
This hearing ends with a major contradiction. After pleading guilty, the defendant starts denying the key facts behind the charge. That's a serious legal problem because a guilty plea has to match the defendant's own admissions.